In my first video, I explained my proposal to set up pub immigration juries to make quick, binding, unappealable decisions on immigration to a nominated part of the UK based on whether or not the applicant would be a good neighbour and a good fit for UK culture. The decision will be made by a jury of 3 UK residents aged 45 plus who have lived here for the last 20 plus years at the end of a 1 hour interview in a pub. The applicant will be online, while the applicant's two sponsors will be in the pub with the jury. The sponsors would also have to face questions on the practical support they would offer the applicant. The procedure will be rough and ready, with no lawyers, judges, or officials able to interfere. The decisions would truly belong to the people. In this video, I will go through the biggest legal obstacles. I will expect you to think these are huge and will defeat the proposal. I will explain how the obstacles can be overcome in the next video, and I'll give you a taster at the end of this one. But first, you'll need some understanding of the main obstacles. Number one, human rights law. Pub immigration juries, as I propose them, would probably breach the European Convention on Human Rights in all sorts of ways. This convention is part of UK law as the Human Rights Act. Article 6, the right to a fair hearing. This would be breached because the interview would allow no legal representation. The jury are not trained, the questions are possibly arbitrary, and there is no appeal. Article 8, right to family life. My system doesn't specifically account for one common reason for applications, being the reunification of families. Article 14, non-discrimination. Challenges are likely on the grounds of discrimination based on accent, fluency in English, culture, religion, age, background. The pub venue and presence of alcohol could be problematic for some people on the grounds of religion. Some people are naturally better communicators. The ban on interpreters could be seen as discriminatory. Exclusion of judicial review. In UK law, government decisions can be challenged for being irrational, procedurally unfair, or biased. I'm proposing to exclude the possibility of such challenges. And if I had to allow challenges for irrationality, many aspects of the procedure could then be challenged. Equality law violations. The Equality Act 2010 could strike down any requirement that jury members must be over 45 as age discrimination. The exclusion of interpreters could again be indirect discrimination on the grounds of nationality or ethnicity. The United Nations Refugee Convention. Asylum claims require careful credibility assessment. Applicants are supposed to be protected against being sent back to a persecuting country. My rough and ready non-professional approach would not be thorough enough. There are other issues too, but I have selected what I consider to be the main ones. As I propose it, the policy would be gutted by numerous court challenges at the least, or more likely completely killed off. So what's the solution to all that? Firstly, the government ignores the courts. Secondly, everybody keeps calm and carries on. Why? Because from now on, it's going to be a roller coaster ride. But it's going to be a roller coaster ride in which we need to keep as many people and groups as possible on the ride with us, no matter how much they disagree. In the next video, I will explain what happens when ministers ignore court decisions and how this could play out in the longer term, so that the pub immigration juries policy could hopefully remain intact, despite the consequences, which will be bad ones. So hold on to your hats.